I'm going to open the meeting of the Board of Adjustments.
Currituck Board of Adjustment
Currituck Board of Adjustment.
for the evening. And okay, so now the first thing we need to do is, I think this is the agenda. Yeah, there we go. Is we've got 4 people, so we have a quorum. So if you could announce that, that would be good.
Oh, me?
Go ahead.
Oh, okay. We have 4 people, so we have a quorum, so we can open the meeting?
Yep.
Okay.
And now I would suggest that since you're sitting in the chair seat, that this is
I'll be glad to move this wherever it wants to go.
what I would say is if you could ask for nominations for chair, and then if somebody makes a nomination, we're going to put the nominations in a list. You know, if everybody nominates everybody else, at some point y'all will stop making nominations. She'll close nominations, and then we'll go through each name. And when you get a majority vote for the chair, then that person will be the chair. We'll move or keep them in the middle, and we'll do the same thing for the vice chair.
Okay.
So I would just open the floor for nominations.
Okay. I'm going to open the floor for nominations for chair.
I nominate Troy Breathwaite for chair.
I second the motion.
And what I would say is, if there aren't any,
Oh.
to ask if there are any more nominations.
Are there any more nominations?
Okay, so close the nomination.
Okay, we close the nominations.
And then I would ask for a vote on Troy Braithwaite for chair.
Okay. Can we have a vote for Troy Braithwaite for chair?
And all in favor say aye.
All in favor, say aye. Thank
Aye.
you for bringing me through this. Aye. And,
So Troy's now our chair.
all right, congratulations.
You can hand him the gavel.
There we go. I'll just pass it right down. There we go.
Now, Troy, you can go through the same process. I'm sure you've memorized it.
Not exactly, but
For vice chair.
okay.
So you would just ask for nomination.
All right. I'll ask for nominations for vice chair.
And you can nominate yourself if you want to.
How about you want to, or do you want to be vice chair?
I'd be glad to do it.
Okay. Craig?
Greg.
Greg.
You did
I nominate
good.
Greg for vice chair.
I'll second it.
And then if you don't have any more, I would ask if there are any more nominations.
All right. Are there any more nominations?
Seeing none, I would close the nominations
Seeing as there are none, I'll close the nominations.
and ask for a vote for Greg
Hammer.
Hammer for vice chair.
All right. I'll ask for a vote for Greg Hammer for vice chair.
All in favor, say aye.
All in favor, say aye.
Aye.
All opposed?
All opposed?
So Greg Hammer is now our vice chair.
Okay.
Mr. Braithwaite is now our chair. Okay, that gets us to the approval of the agenda. What you would do there is ask for a motion to approve the agenda.
All right. Motion to approve the agenda.
I move.
And then you would add second.
Yep.
Okay,
That's
so
fine.
she's going to second. And then you would ask if there's any discussion.
All right. Is there any discussion of the agenda?
And no discussion, then you would ask for all those in favor to vote aye.
All right. Seeing as there's no discussion, all in favor, say aye.
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 All opposed?
All opposed?
So nobody opposed. And the next thing on the agenda would be the approval of the minutes of the November 9, 2017 meeting.
All right. So I'd move to approve the minutes.
Yeah, you can move or someone else can move.
All right.
Either way.
I move to approve the minutes from the November 2018 meeting.
2017.
17 meeting.
All right. Second.
I'll second it.
And then you ask if there's any discussion.
Is there any discussion of the November 9th, 2017 minutes?
If
Was
not-
that the last meeting?
Yes.
Yeah.
Really? Okay.
And then now, all in favor, aye.
All in favor, say aye.
Aye.
All opposed? All right.
And then there is some old business, but let me tell you new business first. This part of why we're having this meeting is because I've been the Currituck Board of Adjustment attorney for a little over 10 years now, and I'm going to resign my position as the attorney. And I needed to have a meeting to do that and have a chair to figure out who to tell that to. So I'm glad to have Mr. Braithwaite as a chair. And I would like to tell you that this will be my last meeting for the Board of Adjustment as the Board of Adjustment attorney, and our firm is going to withdraw as the Board of Adjustment attorney, except for one matter, which is related to golly, I'm not even sure when the hearing was now. And before the November 17th, probably in the spring of 2017, there was a hearing in a matter related to a LLC called Davis Street Holdings LLC, and the Board of Adjustment ruled in favor on an appeal in favor of Davis Street, and the county appealed that to the Superior Court to challenge the Board of Adjustment's decision. So the Board of Adjustment was named as a party in that action, and that action is still pending. And what I'm going to ask you to do is to go into closed session so I can talk to you about advising you on that action. We've had, I believe at that November 9, 2017 motion meeting, there was a prior closed session on this, and some things have changed, and I need to have some direction, and the chair may need to have some direction as well from the board as an entity. And when you're getting advice on legal matters, you go into closed session to discuss that. So what we're going to do is do that briefly, and then unless everyone absolutely wants to go home, I was going to provide a 30-minute or so kind of a primer on Board of Adjustment education as my last act, other than dealing with the Davis Street case. So if everybody's okay with that, then what you would want to do is entertain a motion, and what I'll do is I'll spell out what the motion is, and if someone wants to go into closed session like I'm asking for, they would say so moved, and then someone would second it. So what you want to do is entertain a motion to go into closed session pursuant to NCGS 143-318.11A3 to consult with an attorney retained by the public body on the matter of Currituck County v. Currituck County Board of Adjustment and Davis Street Holdings LLC, Currituck County file number 17 CVS 437.
So moved.
So moved.
Okay, so we have a motion and a second,
Yes.
and then
All in favor, say aye.
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 All opposed?
so now we would go into closed session, and what we typically do is go into the conference room over here. So we'll walk over there, and we'll come back in here when we come back into open session. You would just announce that we're back in the open session,
All right, the Board of Adjustment is now back in session.
and the only question would be, do you want me to give you a little educational spiel, or do you just want to wait and have the next attorney tell you what they think?
I'll take all the education we can get, yeah.
I would like that as well.
Okay.
Everybody's a little different, so
Well, I've done this before, and I'll try and be as brief as I can about it. I tend to get a little bit more wordy than I should be. But it's the last thing that y'all are going to do tonight, so we'll try and get you home. Board of Adjustment is kind of like I said, it's a judge. You got, essentially you're going to have 5 heads up there who, through voting, are going to be one judge. And what your attorney does, or at least what I perceive that role is, and what I did as that role, was I help you with procedure so that you do the procedure end of it right. And I help you occasionally get into the area where you're making the decision. But I don't make the decision. And if somebody turns to me and says, well, what do we do to answer the question for whatever's in front of us? If it's not procedural, I'm going to tell you, I really can't tell you, but here's what you're deciding. And there are 2 primary things that this Board of Adjustment hears. One is variances, the other is appeals. And in all cases, as a quasi-judicial body, you're going to hear things through sworn testimony. So it's going to be someone standing here under oath, just like they would be in court, telling you facts that you're going to apply to the law, which is essentially the code of ordinances with regard to variances or appeals. So the difference between variances and appeals. Appeals arise when somebody gets issued or denied a permit, or somebody gets a notice of violation or some other enforcement action, civil penalties against them. They can appeal. And when they appeal and they apply to the county, to the Board of Adjustment, they're asking you to take the position of the county official who denied their permit or issued the notice of violation, listen to the facts, and then apply the law under the ordinance and either come to the same conclusion as the official, tell them that the official was wrong, or come to some modified conclusion that's similar to the official. But you get to sit in the official's shoes and you get to apply the facts to the law just as they did administratively, but you do it as a body with sworn testimony and evidence in front of you. A variance is different in that it's an exceptional remedy to try and let people, where the county ordinances and all ordinances, they cover about 98%, 99% of the situations that arise. But there's some situations that it's just not fair. It's unnecessary is what the term is for this hardship created by the ordinance to apply to someone. Sometimes that's getting a foot difference on a setback because of different things. Sometimes it's like in the case of Mr. Ennis's case, a change in how the ordinance applies to the number of subdivision lots. You can't change the use of a piece of property by a variance, but what you're doing to vary is most of the time there's a number somewhere in the ordinance that applies, and somebody's asking you to vary that number. So it's a 10-foot setback, I'd like to vary it to an 8-foot setback. It's a 5-foot setback, I'd like to vary it to a 3-foot setback. And when they do that, they're going to come and talk to you about, trying to see where let's see where in my notes here I've got the standards for variances with the county. Essentially, there's, I don't see them right here offhand, but essentially there's 4 standards. One is that there's an unnecessary hardship created by the ordinance. 2, that it's peculiar to this property, not to the people who own it, but to this property based on size, topography, location, something like that. 3, that the owner didn't cause the problem. And 4, that it falls in the purview of the zoning ordinance essentially and isn't offensive to the public peace and public and matters of justice. So when the applicant comes before you, they've got the burden of producing evidence, which is called substantial competent evidence, not just a minimal amount of evidence, but something that actually can persuade you that each of those standards are met. And if any one of those 4 standards is not met, then the variance can't be granted. If all 4 of the variance standards are met, then the variance has to be granted. Now, it can be also granted with conditions. Those conditions have to reasonably relate to what the zoning ordinance and the UDO are related to. And it's pretty rare that boards put conditions on there. But that's something that's best dealt with at the time. And but the key there is the 4 standards have to all be met. It's not enough to meet 3 out of 4. And that in the variance case, they all have to be met with a 4/5 vote of the board. Typically, if there are only 4 people available at the board meeting, there'll be an offer to the applicant. Do you want to do it tonight and know that you'll have to have a unanimous decision, or do you want to come back for the next meeting? and hope that you have 5 people so that you can have a little bit of room to maybe have someone who doesn't agree with it. Sometimes they go either way. But however it works out, you've got to have a 4/5 of the actual body, the whole 5-person board, to grant a variance. Appeals, on the other hand, are a simple majority of the 5. Used to be a 4/5, but it's a simple majority now. One of the things that comes up, and we discussed it a little bit a minute ago, is whether or not there are conflicts. And Mr. Braithwaite, you'll be given a kind of a script to go through the meeting. And at the beginning of the meeting, there's a part of that script where you ask if there are any known conflicts that people have with regard to a particular thing that's going to be heard that night by the board. I think that's a good idea, but you should be cautious that it doesn't necessarily mean that someone won't raise a conflict at or during the hearing or later on. And the parties can raise the conflict, and then the board ultimately has to vote to decide whether or not there is a conflict. Whoever is sitting with you as the attorney at the time will have to guide you through that process. But the areas where conflicts in the quasi-judicial sense are considered to be where someone is violating someone else's right to an impartial decision maker. So if you keep that in mind, you can think of how the conflicts work. So anything that's going to make you partial to one side or the other is potentially a conflict. But the statute spells it out a little bit more clearly as well. And the first standard for having a conflict is that you have a fixed opinion prior to hearing the matter that is not susceptible to change. Now, Mr. Roddy's heard multiple of these things. Y'all heard at least one, and you haven't heard any before. But what will happen is, before the meeting, you'll get a packet of information, and you'll get it via email, or you'll get it via mail, and you'll be able to read through it. And if you spend the time looking at it, you'll probably have a pretty decent idea of what you're probably going to do at the meeting. So it's not saying, but that's not what this fixed opinion, not susceptible to change, is talking about. The fixed opinion, not susceptible to change, is, the easiest example is you've got religious beliefs that would make you never be able to vote for an adult theater or whatever that may come. Doesn't matter what the facts are, doesn't matter what the law says, you're just not going to ever vote for that. That's the concept of a fixed opinion not susceptible to change. Because the difference is, if you're reading the packet and you're understanding, and you come up with a concept that you think you're going to do, you're still basing that on everything at the meeting tracking what you've already seen, right? But you're still open-minded that if the facts don't line up with the way you read it, or somebody explains it different, then maybe you'll come to a different decision. It doesn't relate to your personal circumstances or your personal ideals or an opinion that's just not susceptible to change, like a religious conviction or whatever that you may have that just won't let you do something. The next conflict that's addressed is undisclosed ex parte communications. So ex parte communications are communications for you with any of the parties or their representatives without the other party present. Really without the other party being in this room. So maybe your neighbor who's the applicant. If he comes up and talks to you, the best thing to do is just say, I'm on the board, I can't talk to you about it. Sometimes that doesn't work. That's the best thing you can do. If it doesn't work, then what you have to do is you have to make it, instead of an undisclosed ex parte communication, when you come to the meeting, you have to disclose it. And the reason for that is that you want to give the parties an opportunity to change your mind or to correct facts that you may have heard. And if you don't disclose that communication, you're getting facts from outside that may affect your decision, but the parties don't have an opportunity to address them. So that they could be wrong, they could be right, but the unfairness and the conflict issue and impermissible action is that the parties end up not being able to address some situation that they could if you disclose that communication. So if that comes up, then you'll need to work with the attorney for the steps for how to disclose that. Sometimes it's pretty simple. My neighbor's the applicant. He walked over. He told me, look, there's the drain thing that I'm dealing with, and I said, I can't talk to you about it, and that's the end of it. But sometimes it's more extensive than that, and sometimes it's written via email or letter or whatever, and the easiest thing to do is bring it in, make it part of the record, just put it in the record and go on. But make sure that when you do that, the other party gets a chance to see it and address it. And then the next area of concern is a close familial, business, or other associational relationship with an affected person or a financial interest in the outcome of the matter. So financial interest in the outcome of the matter is usually relatively simple. Will you make or lose money because of the answer to the question? If you will, you've got a potential conflict that needs to be addressed. Close familial, business, or other associational relationship with an affected person, spouse, kids, parents, probably close familial relationship, eighth cousin, probably not. But if you see that situation arising, the best thing to do is to call the attorney who's going to represent the board ahead of time, lay it out for them so they can help you go through the process when the time comes here. Same thing for business and association relationships. Business, it probably comes back to kind of similar to the financial interest, where you've got a close enough relationship with someone business-wise who's appearing before the board that if you rule one way or the other, they're not going to do business with you anymore. And that's where you would start to have a conflict in that situation. Associational relationship, that could be that you go to church or are a neighbor with the person. But just because you live in a 400-person neighborhood, or I don't know if they're any that big in Currituck yet. I guess Moyock's getting ready to do that, but it doesn't mean you're in an associational relationship that's a conflict. But if they're your next door neighbor and they're your buddy, and that's when you start to get into it. Just because they go to your church, that doesn't necessarily mean there's a conflict. But if you're on the vestry with them and you go on Emmaus trips and you go to travel to Costa Rica to build houses with them and spend a lot of time with them, you're starting to get closer, and it's time to talk to the attorney and try and figure out where the line is. And the way this typically comes up is if you know ahead of time that it's going to be a potential issue, you contact the attorney, you talk to them, work out a procedural way to deal with it, and then you address it however they deal with it at the meeting. Usually it will come to a point where the board will vote to either excuse you or not excuse you. The other way it arises is one of the parties is up here at the table and they say, I object to Mr. Roddy hearing this. He's got an undisclosed, ex parte communication. The way you fix that quickly is say, well, I'll disclose it. But if it's one of the others, then it can come up in a meeting that way. And I've seen it come up in a meeting that way. And the attorney's going to have to kind of address it on the fly. And they may ask you some questions, and they may, that's where it's going to go. And have any of you been on a jury before?
A jury?
Yeah. Okay. So in the jury, they ask you some questions about where you're from, this or that, and would you be able to make a fair decision based on the facts and the law in this case because of this, even though you've got this background, and you say yes. Now, if the answer is no, then they're probably going to end up taking you off the jury. Same sort of thing here. If the lawyer's going to ask you questions about that, maybe ask you the question about the business concept. would you lose money? Are you going to lose business if this person gets an up or down vote? Yes. Well, then you probably end up going through the process to make a vote on that. One of the things you have to do for both variances and, more importantly, appeals, because the variances you're dealing with pretty particular standards most of the time. Appeals, you're going to be dealing with potentially anything in the ordinance that somebody is in violation of or got denied a permit for. And you're going to have to, what you're trying to do is interpret the intent of the ordinance. And where you start at is what the ordinance says. So the Board of Commissioners, in comparison to this board, the Board of Commissioners is the legislative body. So they're like the General Assembly or the Congress. They vote and pass the laws. They create the laws. The ordinances are their laws that they create. And y'all are like the judiciary. You don't make the laws, but you take facts that are in front of you and you apply the law as it exists to those facts, kind of like a meat grinder, and something falls out the bottom of, is it this or is it that? So in doing that, the reason we're almost always here is because the ordinance, well, sometimes we're here because the applicant doesn't understand it. The ordinance really is no way it's going to ever be in their favor. You'll find that as well. But the other reason, if they know that if there's really a question, if there's really an issue, it's because there's some question about what the ordinance means. So what you're trying to do is determine the intent of the legislative body, the Board of Commissioners, when that was adopted. But you don't look at what the meetings that the Board of Commissioners had. You start with the text. Essentially, it means what it says, because the way the law looks at it is, if it didn't mean what it says, then they would have written something else. So you start with what it says until there's an ambiguity, and that it's tough for me to tell you what that is tonight, but most of the time you don't have to get past looking at what it says to determine the intent. And I think sometimes boards of adjustment, certain members at times get hung up on what they think, and sometimes you have to think it might mean, and reading behind the scenes, but you really have to go back and stop and read what it says and start there. And I think that's one of the fundamental things that I see that I do see some mistakes sometimes from Board of Adjustments for doing that. That brings me back to one more thing about variances in the board. Why is there a Board of Adjustment? Why doesn't the Board of Commissioners just do all this? I think there's two reasons. One, particularly in bigger areas, it's just administrative. If the Board of Commissioners had to deal with quasi-judicial hearings at every one of its meetings, at least in a city like Raleigh or somewhere like that, it would never get any business done, and they'd be there till 4 a.m. every time they had a meeting, or they'd have to have 4 meetings a week. So, Board of Adjustment is a relief valve administratively to take that quasi-judicial burden off of the Board of Commissioners. The other thing I believe is that the Board of Adjustment is there to take some political heat and issue off the Board of Commissioners, because y'all aren't elected, y'all are appointed. They, in all cases, there's boards of adjustment in every city and every county, so it's not just y'all. But in all cases, it gives the elected officials some ability to say, we didn't do that. They did that. And that's not always the case, but it gives them that outlet. And I think that's part of the reason why it exists. And then the reason why variances and why the board grants variances, and boards of adjustment would probably initially most focused on variances, adjustments, variances. That's where the language comes from, more than appeals. The appeals kind of came into the process. I mean, boards of adjustment are, I'm thinking they're getting to be about 100 years old, so it's not a new concept, but over time, the appeal process has moved into the board of adjustment arena. But what happens is, if there's a regulation that a county or a town has that goes too far and makes your property not useful for anything in particular, or sometimes if it just makes it really greatly reduces the usability of it, then that regulation can result in a constitutional taking. Essentially, procedurally, the same as if somebody wants to take a highway across your farmland, it's an eminent domain taking under the Fifth Amendment. So variances as an exceptional remedy are kind of an outlet for that. When that's the situation, it gives a remedy to help a county avoid the situation where some regulation is applying to the extent that it shouldn't apply in a particular case, so there needs to be an outlet. And that's part of what variance is and what the Board of Adjustment does. The last thing that I want to talk about is the evidence that you see. I'm sure y'all have all watched Law and Order. Can't even remember what the show. I don't have TV anymore. I haven't had TV in about 6 or 7 years, but it's Law and Order.
Mm-hmm.
And I'm sure some of you probably been in a courtroom or been involved in litigation or been involved in something beyond a traffic ticket where somebody had to give testimony and somebody objected and there's fights about whether or not evidence can come in. Like I said, y'all are basically a judge, but you're not bound to follow, under the statute, you're not bound to follow the strict rules of evidence that a court has to follow. But a lot of times you'll have applicants that don't have attorneys. And you may have the staff represented without Mr. McCurry. And in those cases, you're not real likely to see many objections. But if there's an attorney on this side and Mr. McCree's here on this side, I can just about guarantee you that at some point somebody's going to object. And most of the time, they're going to give you some explanation for why. And the chair will typically look to the attorney and say, should I sustain or overrule that objection? But what it comes back to is the concept of what you're looking for is substantial competent evidence. And let me see if I can go back. 388. So the term competent evidence doesn't preclude reliance by the decision-making board on evidence that would not be admissible under the rules of evidence in a courtroom. If the evidence was admitted without objection and the evidence appears to be sufficiently trustworthy and was admitted under circumstances that it was reasonable for the decision-making board to rely on it. So you got to have, for hearsay and stuff, if you've got a staff member handing up a letter from the DOT and no one objects to it, it's probably going to meet that standard, right? Because there was an objection, and it's coming from a sufficiently trustworthy and admitted under circumstances that it was reasonable. If somebody says, my great-grandma out in Washington State told me 6 years ago that this is this, and then you're going to have a problem with the second prong, even if no one objects. And you're going to have a big problem if somebody objects, because it's going to be a potential hearsay problem. And then the other thing in the statute that competent evidence talks about doesn't include testimony of lay witnesses in certain occasions. So a lay witness is someone who's not an expert witness. You or me going to talk about what we saw at an accident, right? What we saw when someone fell down the stairs, compared to the engineer who goes and tells you, how the building fell down, despite the fact that he wasn't there. Or other expert witnesses you see a lot: appraisers, engineers, traffic people. So lay people can give opinions on some things, but the statute is clear that lay people can't give testimony that the board can use in its decision making on the use of property in a particular way would affect the value of other property. What they're saying there is, if someone's saying the value that somebody's doing something that's going to affect the value of another piece of property, they need to bring an appraiser. And that appraiser needs to go through the process of being deemed an expert, and they need to say it's affecting that other property. Not what you commonly see is, I can't let him build that next door to me. It's going to affect my property value. That's not competent evidence under the rules. Same thing for the increase in vehicular traffic resulting from a proposed development would pose a danger to public safety. That's probably the most common one. Everybody who gets anything commercial anywhere near them that they don't like, they come in and say, this is going to make traffic just horrible, and somebody's going to die. Well, if they don't bring a traffic engineer to tell you that, then you really shouldn't consider it as part of your decision-making process. And then they've got kind of a catch-all: matters about which expert testimony would generally be admissible under the rules of evidence. You don't have the neighbor come and talk about the engineering of whether or not a building is going to stand up, and make it through a hurricane, et cetera, et cetera. And you have an engineer come and do that. So those are the big issues with regard to testimony that you're going to see. And sometimes what happens is the people just do it anyway. They kind of blab. There's nobody here to object. And what you may have is the attorney may tell you at the end, you heard evidence about this, this, and this. I wouldn't base your decision on this, or this. If it doesn't affect your decision and you want to talk about it, that's fine. But you need to base your decision on facts other than that, because it's going to get overturned if it goes overturned. One last thing to talk about is due process concerns. Okay, so we talked about you're going to have two parties typically. You're going to have an applicant in the county, and there's a difference between parties and the public. Okay, what you have is public hearings. When most of us hear that term, we think that's an opportunity for the public to come and talk. I think in absolute theory of how a Board of Adjustment should work, the public shouldn't have an opportunity to just talk at a public comment period like the Board of Commissioners has a public comment period. But it's real uncommon that any Board of Adjustment I've dealt with does it that way. Almost all Boards of Adjustment let the public have comment, but I like to remind the public that, one, they're under oath, and what they're doing is not providing public comment like you do at the Board of Commissioners on just anything, but it still needs to be substantial competent evidence related to the issues at hand in the case. And that's how you address, as a chair at some point, someone who comes up and rambles on about, I hate my neighbor, and he did all this to my car, and he did all this to this, and I really just don't want this to happen. At some point you say, we're dealing with these standards. Do you have any testimony as to how those standards are or are not met? And that's how you deal with that. So the public may have a right to testify, and you're typically going to allow them after the parties. Public doesn't have the right to question. Only the parties get to question each other. But it's just like a court case where when the county gets up here and they have somebody giving testimony, when they're done with the testimony, you need to ask the applicant, do you have any questions for the county person? And then same thing when the applicants, people come up and they call witnesses after their testimony's done, you ask the county representative, particularly if there's an attorney here, do you have any questions for the applicant? And so the more opportunity you give the parties to ask each other's witnesses questions, the less likely you're going to have a due process problem. Every once in a while, a board will just, okay, he's done, go sit down, and that's when somebody sitting over here will probably raise their hand and say, I think so-and-so wanted you need to ask them some questions, or you need to ask them if they needed to ask them a question. Call them back up here. The other thing that's like a courtroom, if you have attorneys here, they'll probably want to maybe do a little bit of an opening argument. Okay, so the attorney typically won't give testimony. Sometimes they'll get sworn. When I'm appearing before a board, I don't want to be sworn. I don't want to give facts. I'm arguing how the facts that someone is testifying to are going to apply to the law. Some attorneys are going to get up and try and give facts, and maybe if they know them, they're allowable. But they may want to do a little opening, and then at the end, they may want to do an argument to kind of wrap it up for you. And I would recommend that whenever that is available to you, it's a benefit. Because what you're going to have is you'll have Mr. McCree on one side and you'll have another attorney on the other side, and they'll come up and tell you how they think you should apply the facts to the law and where the issue is. You know, and where the real, you know, where the rubber hits the road about what you're trying to decide. And it helps. I mean, that's why they do it, because it helps to bring it all together so that you've been here for 2 hours and heard a bunch of testimony and you're kind of all over the place. They've thought about it ahead of time. Let me show you how that testimony applies to the law and get you this answer. And I think that's a benefit that you should always allow that and seek it if possible. Anybody have any questions?
So how much dialogue amongst the board members is typical during that, or is that not something that happens?
And do we do that in front of everyone?
Yes.
Or-
The concept of a closed session like we did for a Board of Adjustment is just exceedingly rare.
Oh, okay.
Yeah, the only reason that we went into a closed session was because we were talking about litigation that was out of this. The majority of what you have to do has to be done in open session. Now, the reasons for closed, there's 6 or 7 reasons in the statute that you can go into closed session. They would all apply to the Board of Adjustment just like any other board, but one of them is for buying real estate. You know, you're not going to be doing that. The other one's for personnel matters. So you start going through the list. About the only thing you're ever going to have to go into closed session for is probably to talk to the attorney. And most of the time, there's not going to be a reason to do that in a meeting, unrelated to a matter that you're hearing that night. The one thing that I have dealt with it before with a Board of Adjustment in a meeting is when something from litigation had come back. So I had to go. I think I had to do it. I can't remember if someone else had to do it and I somehow knew about it, but I think I was involved in one where we had to come back, and then I had to go into a closed session and explain to the board, this is what the judge's order says you got to do. And that's me providing advice so that you can come back and comprehend. But in general, the Board of Adjustment could do that out here just as well as it could anywhere else. You don't really have the same need for attorney communication, confidentiality that the parties or that the Board of Commissioners may have, because you're really not real likely to get, as a body, get sued, because there's just not the mechanism is an appeal through that process, like the Davis Street case, where it's not really, nobody's going out to get testimony and stuff. But for the discussion part of it, not with the attorney, it's common that there's discussion and questions for witnesses, and there's discussion among members during the witnesses, and I guess going back to just kind of step through the procedure, what you're going to do is you're going to call a case, you're going to open a public hearing, and if it was a courtroom, you'd ask the party with the burden, the plaintiff, to go first. The typical thing that the Board of Adjustments do is they let the defendant, essentially the county, go first, because staff's just typically better prepared to get everybody kind of in the same page. And I can see the attorneys, if both sides have attorneys, they may want to do it differently, and Mr. McCree may agree to do it some different, a more traditional courtroom type way. But most of the time, it benefits everybody to have the staff come up and kind of give their testimony and overview first, because a lot of times you'll have somebody here who's an applicant who, they don't have an attorney, they've never done this before, they don't know what they're trying to do. So it gives staff some ability, staff's helpful to everybody in that case. So staff would go first. They give their testimony, they'd ask their questions, then the applicant goes, they give their testimony, staff, Mr. McCree asks their questions, and then you would have, okay, is there any public comment or public testimony on substantial competent, please come forward. Those people will come forward, they'll give their testimony, applicant asks some questions, McCree asks some questions, they go back, the next person. When you're done with those people, if you still have evidence that you want to ask somebody about, you would ask, can you come back up? Can you come back up for the board to ask questions? And that may result in him wanting to ask questions or him wanting to ask questions. But then ultimately, when all the evidence part of it's done, you'll close the evidentiary portion of the hearing, and that's when you have quote-unquote deliberations of the board. None of y'all are attorneys, I'm guessing. None of y'all, Tom's got a few years of experience doing this, but none of y'all have done this a whole lot recently. So the formality level of breaking apart the public hearing and the deliberation, it typically falls apart. You'll get 3 comments in, and somebody will say, well, what did the staff guy say about so-and-so? Come back up here again. And to do it perfectly right, you'd probably either, as a chair, reopen the public hearing to have the evidence, or as a body, I vote to open the public hearing and then take a vote and then reopen it. But it's also not atypical for it just to happen. And as long as they're testifying to it here at the hearing, you're not down the hall and it's on the recording, it's probably, if somebody as a lawyer is going to go to court and argue, well, the guy gave testimony that everybody heard and everybody had a chance to argue about outside of the quote-unquote public hearing course, it's just not likely to be something that's going to be a winning fight in court. But again, to be as formal as possible, you'd want to do some opening or reopening, but it just doesn't happen very often.
Yeah, my experience was that applicants not represented by attorneys will tell you too much.
Yes. Yeah. And another thing that you can err on too, I usually suggest to err on the side of letting them tell you too much and letting the public tell you too much rather than cutting people. If people have an opportunity to voice whatever they want to say, there's less risk that they can have a challenge with you. You create some risk by saying no and cutting them off. Just by cutting them off, you don't know what they're going to say. But if you just let them have their say, 1, it cuts off that risk, and 2, some people just want to have their say and be done with it. Some people just go away after they have their, after they've had their say, that they're comfortable with whatever the decision is because they've had their say. So I would caution you to be careful about cutting anybody off. And, and typically that only comes up with the public or with an unrepresented party who just continues on about something that's completely unrelated to what you're trying to deal with. But even then, it's a lot of times just easier to, let's just let them roll through it and they'll stop talking and we'll move on.
I was more representing applicants that will tell you stuff you don't need to know.
Yeah.
Like years ago, the guy who was opening a record company and was appealing And he went on to tell us, especially planning was eager to hear that he had filled in a pond on his property. And of course, the planning board was like, you filled in a pond? You didn't get permission to fill in your pond. So he actually just,
Yeah, and people have to be,
problem.
those folks have to be careful. And that's why they really should hire, an attorney to come with them, because they don't want to dig new holes for themselves with the planning department. And even worse, they're not only digging them, but they're digging them under oath. So it can be troublesome for people. And the other thing too, you see, I see it particularly when I'm sitting with the board or with, a commissioning town council type board. When somebody comes before, sometimes they're real, staff presents it in a way that they're real likely to get what they're asking for, and they come up and call people a bunch of names, and and sometimes it just doesn't go in their way. But usually I recommend that even if they're rude and obnoxious and do whatever to y'all, that you still apply the facts of the law and just do what you have to do and let them deal with the karma associated with being unpleasant people. But that does happen as well. I've seen people, I swear I thought they were getting ready to give everybody on the board a finger. Just sit back and go, these people are not helping themselves. But sometimes that happens too. Any other questions? Well, I wish you luck. I've enjoyed being the attorney for the Board of Adjustment for the last 10 years, and I've learned a lot and met a lot of interesting people. This is a whole new board and a whole new round of people, and I hope potentially to be in front of you with, avoiding you having people not have attorneys in front of you. And I hope to see you in that regard sometime if I don't see you otherwise. Thank you.
Thank you.
Yeah.
Thank you.
There is a last thing on the. Are there any announcements? Is there going to be a meeting next month? Sure.
To my knowledge, we don't have any cases right now, but that there may be.
Okay.
Something might come up. So.
But there aren't any other announcements. The next thing would be somebody make a motion to adjourn.
I make a motion to adjourn.
A second.
All right, all in favor, say aye.
Aye.
All right.